right, so we'll take this question here from Thomas. So Thomas says, it's been 7 years and I pay my child support. She will not let me see them and she refuses to listen to the court order. I'll start out first thing in almost every single state. Child support and visitation are two separate issues. If you don't pay your child support, that doesn't mean they can withhold visitation. Now, there are criminal penalties to not paying child support, but it has nothing to do with visitation. So, Jake, I'll turn it over to you. In the state of Kansas, you get a dad that comes in and says, I got an order. I'm doing everything I'm supposed to. She's not following the order. What do you do?
First step would be to file. It's 7 years. Um, there's a procedure in Kansas to file an emergency order, and I would be hesitant to do that in that case, since if you haven't seen the child in 7 years. I would be hesitant to file an emergency order just because of the lack of communication. However, I would immediately file a contempt action. You can file it in the same case as the domestic matter. So you file a contempt, say that she's not following the court order. She's in indirect contempt of court by not allowing you visitation. That's just assuming in the court order that you do get visitation. And then on piggybacking that, I would file a motion to modify parenting time to at least try to get more time with your children. Now, the court may disfavor that because of the lack of communication. However, they're going to take it seriously because she's been alienating you for 7 years. And in Kansas, that is, like I said previous on this show, that's a major factor that courts consider if one party is trying to alienate another party. In Kansas, you have a constitutional right to parent your child. And if one parent is withholding that right from you, then, they're going to have a difficult time at trial.
Yeah, and I think, and here's the piece too. So my opinion, a lot of guys jump straight to, I want to file for contempt. I want to file for contempt. I want to go after him. In a lot of instances, it may not make sense. But in an instance like this, we call them order for show cause.
Mm-hmm.
We're going to use that to attempt to modify behavior.
Right.
And so you may have a challenge on modifying custody too much at this point because it has been so long. And they're going to look at the wrongs of mom, but they're also going to look at what would be best for the child, given their age, given their school situation, all kinds of stuff like that. And I'll kind of I guess Thomas's question was more two parts. So I would say order for show cause because you're looking to modify behavior.
Right.
And that's your order that has teeth to be able to penalize them to modify behavior. First time you file it, the judge is going to be like, you better change or else. Second, third time you show up there, they're going to be more inclined to bring the hammer. And I guess this probably plays more into the question. And I think this is probably a pretty short answer. So what can I do if I don't know where they live and the mother's kept them away? Probably private investigator.
That's exactly what I was going to say.
Is probably going to be your only bet. To be very candid, it's very hit or miss if you're going to hire a PI. But if you get a good one, they will track them down wherever they are. And they will at least get you an address. And if you don't have a custody case, you'll probably, that state that they're in or that area that are in will probably have jurisdiction. But you're going to have to go find yourself a PI that's going to have to put in some work to locate where they're at. And if you find a good one, they're going to be able to find where they live.